Good evening. You're watching The Womxn Show. I'm Lenina Rassool. The trial of a sexual offences case is often referred to by survivors and organisations as a period of secondary trauma. On a broader scale, the way that sexual offences have been tried has long been labelled as problematic. Often it seems as if the victim is on trial, given the way they are interrogated to figure out whether a crime of rape had actually occurred. The most recent example of this was the court case of Pastor Tiemmie-Duncan Attorneys, where one of the accusers, Cheryl Zondi, chose to testify in public. While being interrogated by Attorneys' defense attorney, Peter Dauberman, even the judge intervened when Dauberman asked the victim whether she knows how many centimeters the pastor had penetrated her. Today we'll be looking at the court process for sexual offences and digging into some of the confusing and infuriating processes that we see in the media. But before we do that, Edna Kengola will give us a short look at how and how many sexual offences move through the justice system from the moment of reporting the assault to the courtroom and beyond.
As women and communities around South Africa are calling for no bail, no parole and harsher sentences for perpetrators of sexual offences and rape, we wondered if there has been any progress. And according to the 2018-2019 annual report by the Department of Justice, it looks like we have, as they've just reported their highest conviction rate for sexual assault ever. In isolation, this may seem like good progress, but when compared to the numbers, they tell a different story. In 2018-2019, the Department of Justice reported a highest ever conviction rate of 4,724 convictions out of 6,353 cases finalized with a verdict. But when compared to SAPS data, there were 50,108 sexual assaults reported in the time period. If we compare reports to convictions, roughly only 10% of perpetrators were convicted. A 2017 report by the Medical Research Council on Attrition in Rape tells a similar story. And an article by Becky Sesa, the study tracked almost 4,000 cases of rape from the moment of reporting to the conviction and found that less than 1 in 10 cases, just 8.6%, resulted in someone found guilty. Why? Well, again, the Medical Research Council data tells us that in 32.4% of cases, there was insufficient evidence to prosecute. And to sign off, let's also consider that of those 8.6% convictions, only 3/4 of perpetrators were found guilty, received prison sentence, and went to jail.
Good evening and welcome to The Womxn Show. We're talking about sexual offences and the justice system. To unpack this, we're joined by Lynn Hill, who is a survivor and who was assaulted when she was 15 years old. She's now a professional speaker and a life coach. We have Marlin Duncan, who was an officer with the South African Police Services for 14 years as a detective. And is now a candidate attorney at Tiemmie-Duncan Attorneys.
That's correct.
Yes, and we have Jameelah Omar, who is a senior lecturer in criminal law and procedure. Thank you so much for joining us.
Thank you for having me.
So to kick off the conversation, one of the most sort of notorious trials recently was the Cheryl Zondi trial, and in particular her defense. We've pulled a clip from that interrogation in the courtroom to just kick off the conversation and have a look at the types of questions that are asked and what that looks like. Let's have a quick look.
Forever.
Yes.
And you're quite clear on what happened in that room
Yes.
on that occasion.
Yes.
You can't be mistaken in any way.
No.
That's exactly what happened, you sure?
Very sure.
Just coming back to the first occasion that you were in his room. When he pushed you backwards onto the bed, your feet were on the floor.
No, they were not. They were slightly bent. So the bed was, the edge of the bed
Yes.
was just below the back of my knees.
Were your legs hanging over the bed when he
but
pushed you back?
They were hanging over the bed a little bit.
Were they not hanging down
No.
over the edge of the bed?
No.
How's that? If you were standing with your back to the bed and he pushed you onto the bed, then logic tells me that your legs would have been hanging over the edge of the bed from the knees down.
My legs were hanging from just below the knees. That's what happened.
Was the bottom half of your legs hanging vertically
No,
on the side of the bed?
diagonally. So it was an acute angle.
An acute angle.
Yes.
Were your calves on top of the bed or off of the bed?
So the edge of the bed was here. Okay? Here.
Yes. Indicates just below the back of the knee, my lord, on the bottom half of the leg. I understood you to say earlier on that you were lying completely on the bed on that occasion. In other words, from your feet to your head.
Well, completely
Yes.
does mean the majority of my body was on the bed.
No, completely and the majority is not the same thing.
Well, then I stand corrected.
So that was incorrect when you said earlier in evidence.
It was not incorrect. There was a miscommunication.
That's what you said. There wasn't a miscommunication.
The fact of the matter is the client pushed me on top of his
Lord,
bed.
we're not arguing about the fact of the matter.
I'm not
We're
arguing
talking
with you.
about what you said, not about what my client did.
Okay.
That was a short clip of the trial between Cheryl Zondi and that of the accused pastor Timothy Omatoso. And that brings us back into studio. So, Jameelah Omar, I want to start with you there is a perception with sexual offense trials, and we don't often get to see what happens inside there, but especially after this one, then victims are sort of more interrogated than perpetrators. It's as if they are at trial, and this video certainly seems to show that. As someone who studies criminal law and procedure, is this generally what it's like?
So South Africa has a very strict adversarial criminal justice system. Each side must orally, in court, present their version. So everything is via oral testimony, and defense. The defense's version is also put through orally. So there's a lot of emphasis on cross-examination as a way of testing evidence. And unfortunately, in my view, many defense attorneys see their role as undermining the complainant as a way of representing their client's interests. I mean, in part, and I can say this as a lecturer, that I think our legal education is also part of the problem, with more emphasis being placed on adversarial training, how to cross-examine, how to put your point across in moot court, and not enough on the ethics of how to question someone with care, how the fact that your role as a lawyer in court is assisting the court with finding the truth, not with tearing someone to shreds on the stand because your client is paying you. I think also because of the way patriarchal norms are so embedded in our society and in our courts and in our processes, defense attorneys are given a lot more freedom to ask irrelevant questions in sexual offense matters than they are in others. So questions that are irrelevant, like sexual history, clothing, lifestyle issues like how much do you normally drink, how many boyfriends have you had, those kinds of things are not relevant. And yet a lot of latitude is given to defense attorneys to ask that. The prosecutor doesn't object enough and the court doesn't intervene enough. I mean, of course, it is the accused on trial, and when the state cross-examines, they will, of course, also try and pick apart the accused version. But what's different about the complainant is that they are not the ones on trial, and yet their life and how they choose to conduct themselves becomes the central focus of saying, well, either it didn't happen, or in most cases it did happen, but she said yes.
And the issue of consent.
Exactly, and that becomes the point of cross-examination, to say, I mean, in the clip that you just showed, it's actually quite pathetic, if I'm honest. This debate about, you said it was the whole of your body that was lying backwards, now you're saying that part of your legs were hanging off. Well, which is it? And the defense attorney tries to raise those minor discrepancies to say, look, if she's lying about where her legs were, then it's likely she's lying about the entire incident.
Yes.
Yes. But that's not helpful to anyone, and I think that's a very bad cross-examination style. I think there are better examples out there, but you're right, because the bulk of our cases happen in the magistrates' courts, which are not reported and not usually filmed, we don't get to see. So there are probably also worse examples to draw on.
Okay, that's very helpful. I want to just ask Lynn whether what Jameelah's just said resonated as you have been through court and an interrogation.
Totally, it resonated. Thank you, Jameelah, on the count of patriarchy, on the count of style. So there I was, a 16-year-old in the Supreme Court, but that case happened to be in camera because I was obviously a minor. And the question of relevance, which almost undermines the principle at stake, and that principle is violation. I was accused of looking younger than I looked on that day, because I stood in the Supreme Court in my school uniform instead of a jeans. So the irrelevance of how old I looked and the age became an issue. But I think, and as I was watching Cheryl's nonverbals, where he took it and he escalated, she was at a point of starting to lose it, where she literally got up out of her seat to say, if this was what it looked like and this is the bed, that is where my legs were. I think, so I was victimized totally, but I think the lowest part and the lowest point was being told by this stranger that I was such a bright academic student and that I was so bored in my life that I thought all of this up. And that I wrote the journal because I journaled my feelings, I journaled the detail after the rape. I was so bored that all of that boiled down to an overactive imagination. And that was, actually, it felt like hours into it. And when he said that was my point of actually, I think, respectfully losing it. And I said to him, all I can ask you is that if it were your mother or your sister or your wife, would you be asking the very, very same question? And I think that was my moment as a victim of victory in that courtroom. But for me to have stood up in that way, the strength that it took, oh my gosh, and all of the irrelevance, what I looked like, the fact that I was held accountable for rocking up in a Supreme Court in my school uniform was used against me. They said that I wanted to emphasize an innocence that I didn't have. So I resonate completely.
I mean, and again, it just sounds ridiculous, actually, to a reasonable person. If we, if you want to talk about what is reasonable. I want to come back to something else. And Marlin, maybe you can weigh in here, because I'm aware that you could sort of look at, you're our link between the police investigation and sort of the court process, because you've now done both.
Yes.
One of the main issues is that rape and sexual assault is often a single victim crime, and it occurs sort of in secret. So there are often no witnesses, and this is what brings us to this trial and to the interrogation to determine who is saying, who is telling the truth, I guess, about what happened. And we know that the one side of it is the evidence, and that within our conviction rate, most of those convictions are where DNA evidence is present, and so that proves that something happened, or that the rape happened. But there's also, I've been reading up on the cautionary rule and caution that must be applied in single witness cases, actually, I think is the term. Can you just unpack that? Could you just start unpacking that, and Jameelah, afterwards, if you feel there's something to weigh in on this caution that is applied when there's a single witness, and what that means specifically for sexual assault cases?
Basically, the court has to consider all the evidence placed before it. All right? So all the evidence, whether it be evidence in testimony, evidence during cross-examination, or evidence which is just in respect of the statements given, witness statements, also the physical evidence like you said, the rape kit or forensic evidence which was obtained, all of that needs to be taken into account. What makes it difficult, what makes it difficult is that when there is nobody or no one to corroborate what is being said by the victim, that the victim in certain instances, such as where the rape occurred and there was nobody to observe or to explain there recently or shortly after the incident what had just happened, it's difficult for the court, but not impossible for the court, to believe, or to, even though the rule is that evidence of a single witness must be taken with caution, the court can still regard that evidence as being so credible or substantial enough, even though the court, even though it's a cautionary rule, or which must be applied in respect of a single witness, yes, to say that it's his word against her word, the court still has a duty to consider that evidence, and the credibility of the evidence itself in itself speaks a lot. And just to emphasize the fact that cautionary in itself says that the court has a duty to weigh up the evidence with a measure of caution, yes, but in itself it does not mean that what is being said by the witness or by the victim is untruthful. Do you understand? Okay.
Jameelah, there's research, or I've read, that this cautionary rule historically held a lot more weight for sexual offences specifically. Is that true? And I'm interested in how, the commentary I did, if I might just be blunt on the show, is that, women, it meant that caution must be exercised when women report sexual offences, because they are prone to, lying. And is that something that you've come across?
Yeah, so I mean, the cautionary rule is a general rule,
Yes.
right? And it applies to different categories of witnesses, or it can apply to different categories. A single witness is one such category. An accomplice would be another category. So the court can treat an accomplice's evidence if they say they make a deal with the state and then testify against their co-accused. The court can treat, because they obviously have they would have they would have the incentive to say it was the other guy. Another category that no longer exists in South African law is the cautionary rule in relation to rape complainants. So this was a separate category of witness that the cautionary rule could apply to, and that was anyone who laid a rape complaint. And this, of course, happened at the same time. This existed in our law at the same time that rape could only be perpetrated against a woman. So it did only apply to women rape complainants. And it was true that the court could treat a rape complainant's evidence with caution. And this dates back to, always, I suppose, when it was, when law and society and everything else really was dominated by men. And there was this perception that if a woman lays a rape complaint, it's either because she wants revenge against that man for something, or because women just lie and are prone to hysteria. And so there were rules built into the common law, like unless a woman immediately runs down the street screaming that she was raped, then she could be taken, then her later report could be treated with caution. Because if you were really raped, then you would immediately want to tell everyone. And of course, more recent literature tells us that that's not true. Everybody reacts differently. The one thing I just want to emphasize is that all rape cases won't be single witness cases, even if it happened in secret and there were no eyewitnesses, because if a rape kit is done, then that will be testified to by a doctor, or any injuries, that is corroborating evidence. The police will give evidence of the investigation, that's also corroborating evidence. A family member or friend could be called to testify about the complainant having reported to them before they reported to the police. So there's lots of possibilities for corroboration.
And so I just want to bring back to Marlin quickly. Thank you. That was very interesting. And I think, just before we go back to Marlin, it also speaks to sort of even though it's abolished or no longer active, there is a historical bias in the law with regard to sort of judging rape victims.
Absolutely. And it isn't only at the stage of during the trial, because we only have about 8 to 12% of rape complaints ever get prosecuted at all, never mind how many get convicted. So we have about an 8% on average prosecution rate. There's about a 4% conviction rate. So even at the stage where the NPA, or the National Prosecuting Authority, has to decide which cases to take to court, I would say they are applying a cautionary rule at that stage already. They're already deciding, is this a case that I can prove? Is there enough evidence? Is this someone that the court is going to find to lack credibility? Is there sufficient forensic evidence that will support this? If this is a case that's just between two people and there's no corroborating evidence, that's not a case that's ever going to get to court.
Sorry, we just have to take a short break, but we'll be back after this. Welcome back. You're watching the Womxn Show. We're talking about sexual assault and rape within the courts and the justice system. So coming back to the conversation, Lynn, I just wanted to chat to you about the sentence that was received in your case. And I know that an additional charge of attempted murder was added onto that, and that meant that the sentence could be longer, but it actually turned out not to be. Could you just tell us more about that, and also what that meant to you as someone who was the complainant?
totally. I think I alluded to in last week's conversation that I was betrayed by the bail, first of all. I think the sentencing was just then another added betrayal. The fact that an expectation was set when it moved from the regional court to the Supreme Court, that 10 years was the maximum in the regional court, and that he deserved, by virtue of the level of crime, he deserved so much more. And I was almost psyched up by the state prosecution that they were pushing for maximum penalty, and that maximum penalty they were looking at was between 25 and 30 years. And I chose not to be, the courtroom was just, it was too horrific. The experience was so horrific the first day. I stood outside for the second day. So I was not present in terms of sentencing, which is why, and I've never asked my parents, and I didn't even want to ask them today or last night. So I don't know what it was verbatim in terms of what was suspended, what was full. But I remember standing outside there, and they came, the door opened, and they came out, and I could see on their faces. And all I asked was how much, and they said 10. And 10 was, remember that there was 3 months that had passed between the regional date and the Supreme Court date. And I remember standing there thinking, is this what those added 3 months was about? Because actually it then translated into nothing. And so I felt betrayed. I felt betrayed for having spoken my truth against all odds. I felt that it was not worth it. I felt that the battle, and obviously that was just in that moment, and then post that moment and many years later, and writing the book now and doing what I do on a daily basis, actually having found the highest purpose in the pain, I guess 10 years was better than nothing from a perspective of gratitude. And that what those 10 years did do, while I felt betrayed by the judicial system, it actually in a way said to me as an individual that there was a system of some form. However betrayed I felt, it could have been that he got away. It could have been so different. And I hoped that many other victims would be able to draw from my courage and my strength. And I think at the end of the day, it's not always just about the sentence. It's about the precedent. It's about the message that you're putting out, even as a victim, to say that it was not okay, that I am fighting for my human right, however unfairly violated that right was, but I will fight, and that this cause is not only about me as an individual, it's really about a greater cause. And between 1983 and 2019, the concept of femicide has now been birthed. And you say, wow, well, it's not a concept that's been birthed, but it's a concept that's become so real in South Africa. And you say, my gosh, so what has happened to the rape rates between 1983 and now? And if we look at the fact that South Africa actually has the highest rape rate, the lowest conviction rate, my goodness, then what does that say about us as a society? And certainly for me, it speaks of not progression, it's speaking of degenerative, and it's speaking of regression. And that needs to be systemically looked at.
I think, Lynn, what you said is very important, all of it, but especially also that your take that there is a system, at least that these crimes are recognized, and coming back to actually as how they move through the current system, which we can say is not perfect. We're working on it, and there have been lots of gains made since 1983. Sentencing is also a very sort of controversial issue and trigger point. And so I wanted Marlin and Jameelah just to weigh in on how those sentences are reached in a way that we can understand it. And so I just want to kick off to ask, in a case, you know, we speak about rape or sexual assault as, you know, it's just rape, but I know that sentencing is affected by the level of injuries, or I've read that. I mean, I've read, let's say, commentary from in the media where it's like, where magistrates have actually said, you know, well, that didn't do that much damage. So these are statements which are out there. Could you just generally tell us more about the statements? Because I'm not actually sure where in the system those statements sit. I'm assuming that damage equals a lengthier sentence. Is that correct? Not correct?
It's correct in the sense that that happens, that a lot of magistrates will hand down a lengthier sentence or a harsher sentence if there's physical injury, but that doesn't exist in law. The rape and many other sexual offences in the Sexual Offences Act have prescribed minimum sentences that are found in the Criminal Law Amendment Act. Those are minimum sentences that should be imposed unless there are substantial and compelling reasons to depart from the minimum and reduce it. And in my experience, presiding officers often find substantial and compelling reasons to reduce the minimum. And one of the key things that comes up in judgments is the lack of physical injury. And this is often cited as a reason to reduce the sentence as some kind of, this wasn't the worst kind of assault and therefore doesn't merit the minimum. I am completely opposed to that. I don't think it has a legal foundation at all, and I think it comes from the same source as our other patriarchal norms, that rape is not so bad just by itself. It's bad if he beats you as well. If he doesn't do that, it's just rape. And I think that is absolutely detestable.
Marlin, you got anything to weigh in on that?
Basically, she said everything, but the court has to consider with each and every sentence, not just rape matters or sexual offences matters, but the court has to consider the personal circumstances of every victim, or the accused, of the perpetrator, the personal circumstances, like is he a family member, the business interests which he has, all of that needs to be taken into account when imposing a suitable sentence. The court also has to consider the seriousness of the offence itself, and in doing so, it has to consider, all the evidence placed before it. That's why it's very important, and I will always emphasize that the moment the victim approaches the police station, that's when the investigation starts, and it only gets to a successful point or completion once the sentence has been imposed, take into account all the factors, all the surrounding circumstances. Also, the court has to consider the seriousness of the offence, as well as like I said, the interest of the community is also one of the factors that the court needs to consider. Say, for instance, like what happened recently in the Unene matter, where there was such a high media uproar in respect of the incident against women, rape against women. So, in itself, the court considers all of the factors, personal circumstances of the accused, the interest of the community, and the seriousness of the offence, in order for it to impose a just and fair sentence. But like my co-speaker said, that the court places more emphasis on the other factors, not like the personal circumstances of the accused, to deviate from the prescribed minimum sentence, which is regularly or probably 15 years to life, I would, speaking under correction. But it's very important for the court to not easily deviate from the prescribed minimum sentence based on the fact that it is such a traumatic, or the rape itself, the consequences of the rape is so traumatic for the victim.
Yes.
Yes.
Could I just add as well? I mean, I think it's worth mentioning that prescribed minimum sentences are a very controversial issue. And many scholars and activists strongly oppose the legislature deciding what is an appropriate sentence. Initially, the prescribed minimum sentences were supposed to be a temporary measure. It was only supposed to last for 2 years, and it was supposed to be a way of making sentences for the same type of crime uniform across the country, because there was too much disparity. Different jurisdictions might be higher or lower. So the prescribed minimums were about bringing consistency back into sentencing. It was supposed to be a 2-year temporary measure. It's now been 15 years or more than that since we've had the prescribed minimums. And one of our constitutional court judges, Judge Edwin Cameron, is particularly takes particular contention with prescribed minimums, arguing that it allows presiding officers not to apply their minds properly, that it removes judicial discretion from presiding officers and instead puts it in the hands of the legislature, and there should be a separation between Parliament and judges, and that our prisons are overcrowded on average by about 150%. Prescribed minimums are not helping us deal with that issue. So I think Marlin is right. You know, it isn't only looking at one factor when a court fashions a sentence, but in sexual offences in particular, in my view, irrelevant considerations are often taken into account in deciding to deviate from the minimums.
And it's interesting because when you're speaking about the issue of prescribed, there's also lots of issues around people in jail for really petty crimes because of prescribed minimum sentences. I wanted to, Jameelah, you spoke earlier about the data in terms of what our conviction rates are. So I think you mentioned 8% go to trial, and we've got 4%. I know that last year the Department of Justice annual report said that we've had the highest conviction rate ever for sexual offences, which is I think
14%.
Yeah, I think 5,004, just over 5,000. And we know that reported sexual offences was around 50,108. So we reckon around about 10% ended in convictions. I'm interested just unpacking. Let's assume, because we cannot assume that all 50,108 of those were, we don't know. They didn't go through the whole system. So, but they were reported. In cases where the perpetrator is found not guilty, okay. And this might seem like a silly question, but is that it? Is that it? They just sort of go free and go. I know that Lynn has spoken about living in the same community while the perpetrator was out on bail, and that itself is an issue. But I often wonder about afterwards, and there have been some calls for civil cases, for complainants to open civil cases. And so maybe the question could actually be, to start with, could you explain the difference between beyond a reasonable doubt in criminal cases, and then in civil cases it's a balance of probability? Am I saying it correctly?
Yeah.
Okay. Jameelah, if you want to start. And then
Sure. Basically the standard of beyond a reasonable doubt that exists in criminal cases basically means that the court, having looked at all the evidence, finds that this version, and this version being the state's version, to be the most probable and reasonable. So it is unlikely, therefore, that any version put forward by the defense is as reasonable as the state's version, right? So it's a high standard. Because the burden is on the state, it's the state that has to lead its case and the state that has to make its case in order to succeed. The defense doesn't have to prove anything. They only have to raise defenses. So they just have to raise the possibility that there was consent or that, I mean, if we're talking outside of sexual offences, that it was in self-defense or whatever. So, but they just have to raise that as a possibility. They don't have to prove it.
So it could reasonably be a possibility.
Could reasonably be a possibility.
That there's other...
Exactly. And if the court finds that the defense's version is a reasonable possibility, it means the state hasn't met its burden of beyond a reasonable doubt. So it's quite a high standard to meet. On the other hand, a balance of probabilities in civil cases basically means balancing the two, which one is more probable than the other. But it's a much lower threshold because it doesn't have to exclude other reasonable possibilities. It has to be the one that is the most plausible, where the witnesses were the most credible, and it's a more equal kind of weighting. Of course, the difference is that a civil case can't determine guilt. So it's not like you can choose, do I want to take this via the criminal courts or via the civil courts. It's an entirely separate process with very different outcomes.
Marlin, just to weigh in on that, and again, I just want to sort of speak to the links between the investigation and I think make clear that the court, once a case goes to court, let's say it's going to criminal trial, it's sort of wholly based on that original investigation.
Yes.
Is that right? And we don't have a lot of time left, so I really want to give some practical advice to people out there about how they can ensure that the case is investigated as much as they can. I mean, for me, it was interesting to find out that when complainants go into the system, they go in as witnesses. They actually, as adversarial as it is, it's not like a civil case where you have two people, each one has a lawyer, and they're arguing against each other, except when you look at the Cheryl Zondi video, it looks like that. It looks like a civil case, which is quite interesting. What advice could you give to complainants or victims who choose to report? And I mean this from the point, and without placing unreasonable expectations or responsibilities on victims, what the police and the justice system is providing is a service. And I often, sorry, just to add, I often say, you know, we need to be as vigorous about sort of these cases as we are when we're applying for a passport at Home Affairs to ensure that processes are being followed. Could you speak to that?
I would say that when a victim reports a case of a rape, many instances, because either it happened either shortly thereafter, there's also instances where it could have happened a few days late after the incident is reported. So I would say that every information which you can gather, whether it be writing something down, whether it be to whom you spoke, the person's name who you reported it to, all of that is very vital in respect of a successful prosecution. Just to come back, or just to touch on it, the fact that the matter itself, the sensitivity thereof, touches all over, from the starting point until the sentence of a rape incident. In the sense that when evidence is collected, right? But the state needs to prove beyond a reasonable doubt, where the court comes in to determine whether all the facts placed before it does prove that the state did succeed in its onus to prove beyond a reasonable doubt that the accused or the perpetrator is actually guilty, yes. But for the state to discharge its onus, it needs to get all the evidence, all the, which you might think is trivial, I would say. Yes, anything, whether it be the descriptive explanation of when giving your statement. Because normally a person would sit down, they would take a statement. Some people would give a statement to 1-2 pages and give a full description of what happened, where other people is required to give more in detailed description of what happened, so that it eventually, when it ends up in court, after being scrutinized by the defense attorneys, does not come to a lack of credibility on the side of the complainant or the victim to show that this actually happened or this incident did actually occur. And also then, as you can see, like I'm trying to explain, that everything touches on each other. The moment you report it, every detail which you give to the police officer that's taking your statement, the evidence kit, the forensic evidence which is obtained either during the time when you get taken to the local or the medical practitioner who examined you, everything which is said to that practitioner also gets taken to, because what, especially now in this Omotoso case, is that the defense will hammer on certain contradictions being placed. Why did you say so? And why did you not mention that? And to almost paint a picture like to say that you are being dishonest or untruthful in respect of your evidence placed before the court. And that's where more most of the cases actually gets thrown out, or the person gets not convicted, found not guilty, based on the fact that the evidence was not properly presented or collected and then presented before the court.
I see. So that's very interesting, and obviously, you know, with the Cheryl Zondi video, that is that evidence is being is memory in that instance. So if, let's say, you're speaking about that, when you're speaking about evidence not collected properly, or once it gets to the prosecutor, he will then look at it and decide whether this is going to be prosecuted or not based on that evidence that was found. For complainants who, let's say, the path to the prosecutor was not followed correctly, is there any recourse for that, or is that case just dropped?
So you're talking about situations where the prosecutor declines to prosecute? So the complainant can request reasons for the decision not to prosecute, and on the basis of that, you can take that decision on review to a high court. So a high court will evaluate whether the prosecuting authority rationally applied its mind to whether to it. So there is some possibility. All that the court can do is tell the NPA to relook at the case. They can't force a prosecution because that's in the discretion of the prosecuting authority. But so basically, I suppose, if I'm honest, there is little recourse if the prosecutor decides not to prosecute. It doesn't mean that they've declined to prosecute forever.
Yes.
So if more evidence comes to light, they can at any point decide to prosecute.
That's interesting. Lynn, we have 1 minute. If you could just, in a system, I think, that exists but is not perfect, and that is, especially with sexual assault victims, very adversarial, and as we've seen, perhaps not intentionally designed to dismiss women's voices, but certainly comes across that way in the current system that we have. You stood up, you pleaded your case, and you survived that. Do you have 1 minute bit of advice for
the system?
Victims, for the system and victims out there?
I think for victims to stick to your guns and to know that your truth counts. And because your truth gets to be cheapened in a system which is trying to follow due process, but through that legal due process does not quite culminate in true full justice. So we spoke earlier of what is a suitable sentence, and I ask, what is a suitable sentence when it comes to someone's life having been threatened, having been violated in the highest of ways? And so where I sit from a victim perspective, it's really about, can the South African justice system begin to redress stuff so that victims will speak out, so that their voices are heard, so that the interrogation doesn't happen at the rate that it does? And can rape kits be made accessible to mediclinics, hospitals, and police stations.
Thank you very much. Thank you, Jameelah Omar. I'm blanking. Duncan.
Thank you.
And Lynn Hill, thank you so much for joining us. I'm overwhelmed by all of the information. We're going to take a short break and we'll be back after this. That's all we have for this evening. Thank you for joining us. I'm Lenina Rassool. Good night.